case set for argument is McWilliams versus McWilliams, case number 29172. See Attorney Fox, is Attorney Wagner. I think we're running early, so we can, oh, and here is Attorney Wagner. Okay. Attorney Wagner, you need a moment or two? I know we're running early.
I'm fine.
Okay, so we're ready to proceed if you are, so. Both parties are represented by counsel this morning for argument. Each side will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. Attorney Fox can reserve time, let me know. Since it's not up on the screen, I'll try to be polite and interrupt you when you get close to that. So you can rely on that. I don't believe there's any need to talk about minors in this case, right?
Talk about what, Your Honor?
You know, if there are minors involved, we like to use initials, but I don't think that's
There are not.
so. Okay. We do record the arguments. They're on the court's YouTube channel, so we ask that you stay at the podium and keep your voice up so there's a good recording. We've read the briefs and we are ready to proceed if you are.
Thank you. Good morning, honorable members of this court, counsel, Ms. Sheets. Thank you for the opportunity today to represent Mr. McWilliams in his case before the court. Mr. McWilliams is a very good man who is financially now destitute and medically fragile. I think the transcript of the proceedings bears all of that out, and that is why we are here today. What I'd like to preface my comments today as I was coming over, I was thinking about how my history is generally in the product liability civil realm, where we have strict adherence to rules. Criminally, I certainly spent a lot of time in the prosecutor's office where we follow rules to protect defendants. The last 18, 20 years or so, I've dedicated my practice to domestic relations. And suffice it to say, I'm sure this court's aware there are no such niceties in domestic relations court, whether they're custody issues at domestic relations court or juvenile court or financial issues pertaining to support. It is difficult sometimes to meander through the process. And as I was reviewing my notes I prepared before today, getting ready, it did strike me on something that I want to start in on. And that was the general belief that somehow Mr. McWilliams received notice of all the proceedings in this, which he has denied under oath at the underlying hearing in this matter. And as I was reviewing, once again, the judgment entry decree of divorce, in addition to noting generally that he had been carted after immediately leaving the hospital to counsel for wife's, to her office to sign this agreement, I noted in my brief that, well, if that was necessary right after he got out of the hospital, why not cart him to the final hearing? Why not pick him up, take him in the car? But as I was looking over those notes that I had taken and looking over, once again, the judgment entry, I took time to notice that the accelerated hearing, which was moved for by Ms. McWilliams, indicated that the final hearing was going to be held December 12th, 2017 at 2 o'clock. So if Mr. McWilliams was expected to have had notice, Mr. McWilliams was expected to appear, if everything was on the up and up, how did we know that the judgment entry didn't require a signature line for Mr. McWilliams? This was filed after being signed by the judge at 2:30. That's the timestamp copy. Somebody knew before that final hearing that Mr. McWilliams wasn't going to be there to sign that document, despite the appellee's brief to the contrary. Interestingly enough, too, if the court reviews some of the other evidence in the case, I did note also that there was a diatribe by text between Mr. McWilliams and his wife after he received the final decree, indicating that, hey, I never received notice of the hearing. Interestingly, Ms. McWilliams responds, neither did I. Now I want to go back, to, I think, really what the crux of the case is, and whether or not, if this court chooses to vacate the judgment of the underlying court, whether or not he'd be successful, because why are we doing this if there wouldn't be a reason to do it? I think it's clear that, I'll back up, he clearly has filed this motion to vacate within a reasonable amount of time. It was a mere few months, couple months after the filing of the decree. So I think that's met.
The trial court actually made that.
I think that's right. I think that's right. Obviously, I think the court can tell from the transcript that finances are a big part of this equation for Mr. McWilliams and whether or not he can even do some of this stuff. So there was a legitimate amount of time that wasn't excessive. I want to go to whether or not he has a meritorious claim. Clearly he has a meritorious claim. There is no dispute in the underlying case that Mr. McWilliams had applied for disability at the time that the case was proceeding, that his health was failing, not just bad, but failing, that he has not only physical problems, but psychiatric problems that include multiple personalities and bipolar disorder. He has gone from being gainfully and substantively employed over the last several years to essentially, as the transcript reflects, earning about $18,000 a year, or on pace to earn about $18,000 a year for the year that the parties were in this litigation. Ms. McWilliams, on the other hand, was earning about $60,000 a year. The parties' length of marriage at the time of divorce was 32 years. The ability to gainfully earn income in the workplace was compromised as far as Mr. McWilliams was concerned. Ms. McWilliams was fully healthy to continue to work in the workplace. I find it hard to believe that under those circumstances, spousal support would not have been awarded, particularly since I'm sure this court's aware that the underlying domestic relations court, Summit County Domestic Relations Court, relies on income equalization. Even though it's not a rule, it is certainly a guideline that's followed in the majority of cases.
Did the court consider the fact that he had made $40,000 to $70,000 and his disability had not yet been approved? 40 to 70 would be in the range of what the wife's income was. Was that?
I don't believe that was considered at all because he really didn't participate financially in the case. It's interesting, and I'll go back to the separation agreement that was drafted by wife's counsel. There's a clause in the separation agreement that says both parties have relied on the financial affidavits submitted by both parties in this matter in assessing how to proceed through the separation agreement and whether or not it is fair. Mr. McWilliams didn't file any affidavits. Mr. McWilliams didn't file any sort of case designation sheet, which is required by the parties. So to the degree that the court could have considered something that was non-existent because the evidence wouldn't have shown, and if I recall correctly, and I certainly am welcome to be corrected, I would like to keep 3 minutes if I could.
3 minutes, all right.
If I recall correctly, I'm not sure wife submitted what his income was on her affidavit. There are 2 lines on each affidavit for the parties to put in the income of each party. The general expectation is you put your own income in, to be fair. I don't recall whether or not she indicated what his income was, but he clearly didn't submit any affidavits in this matter. So I think that the court did not and could not have, to defend the court, consider those issues. What the court, I think, found in the underlying situation was that, and I believe the quote was buyer's remorse, that he signed a document he subsequently did not agree with. Going further, it is clear that wife had retirement accounts that were subject to division as a marital asset, 32 years of marriage. She's not going to earn any of those outside of the marriage, certainly not at any significant issue or extent. Mr. McWilliams, the testimony is, had cashed out his retirement account several years before the divorce to pay taxes on marital debt. So he had no retirement accounts at the time of divorce. Therefore, clearly, half of her retirement benefits would have gone to him, at least according to the law.
Counsel, if you could clear up one little issue that I'm having with the actual judgment entry under the findings of fact. It states in paragraph 8, husband appeared at the uncontested final hearing set for August 22nd, 2017. And my understanding is that was converted to a pretrial.
That's right.
Okay. But then in paragraph 16, it said, on August 9th, 2018, husband testified that he was not under duress when he signed the agreement. And that's not a typo, that is a year later when you're having the hearing on the 60B, correct?
I think that's right,
Policy.
yes.
Nine, okay.
I'm sorry, go ahead.
No, that was my only question. I was a little confused about those dates and making sure the testimony was attributed to the correct hearing.
Yeah, and I think he interpreted that to mean I wasn't under any particular threat. I think the evidence is clear that he had been hospitalized 2 years before that hearing. And a mere matter of days before wife comes over and picks him up from his house, he had spent approximately 2 weeks in the hospital having lost 8 units of blood. Internally, he has what's called esophageal varices. I had not heard of them before this case. I wished I hadn't. But it basically results in significant internal bleeding to the point where they thought he had pneumonia and dementia and some other things that caused him dizziness. That was testified to some degree.
Well, he said he wasn't coerced. Was there any indication that, did he testify he read and understood the separation agreement?
His testimony was he had no time to. That he was basically carted from his house to counsel's office, wife's counsel's office, presented with the document, signed it, and we're leaving. He said he had no opportunity at that point in time to take it to legal counsel to review. I'm not sure there are always financial issues in divorces. How can you litigate these cases when you're splitting one household into two and you're immediately changing the income in half? And then when you know what Mr. McWilliams has or doesn't have, the idea of hiring a physician to come in and testify about what was in his mind at that particular time, or likely in his mind at that particular time, is simply cost prohibitive. So what we're not, to be quite candid, what we're not, and I'm not sure can argue, is that there was an inability to voluntarily sign at that time. What I think is more apparent, based on the facts of this case, is that, for instance, there's references to, wife's counsel filed a motion to continue the November 8th hearing the day Mr. McWilliams was in her office signing the document, that he couldn't attend because he just got out of the hospital. That's in the motion. And that he had called and requested that continuance. Mr. McWilliams was in her office, could have signed that motion. Mr. McWilliams, having been carted to her office to sign the separation agreement, could have been carted to the pretrial hearing the next day and appeared, if that was the intent. There was further a motion to accelerate the final hearing that represents, counsel for wife represents on behalf of both parties. She's filing this motion to accelerate the final hearing. I'm not sure how you do that when you have waivers that you can't represent both parties. It may be a nicety that doesn't exist in domestic relations court, but it is a fact in this case.
3 minutes and 9 seconds at this point.
Thank you.
Want to reserve that or keep going?
I want to finish this off if I could.
Okay, I'll keep you running.
That's fine, thank you. So at the point in time that there's this apparent representation to the court, Mr. McWilliams, again, was carted to counsel's office to sign this rather important separation agreement because it's going to dictate the rest of their lives. Couldn't be carted to the office to sign the motion to accelerate the final hearing. See, from the transcript, it was acknowledged because he was personally informed of the March 7th, 2018 hearing date, about 4 months later, which was in his mind at the time. Given the text communications between both Mr. McWilliams and his wife after the final hearing, that she didn't even get notice of that final hearing, and the fact he would have come in and contested the viability of that separation agreement, I think all buttresses the fact that he didn't get notice, that he would have appeared for that final hearing, and that he would have contested the validity of that document. Thank you.
2 minutes and 12 seconds. For rebuttal. Counsel, you've got 15 minutes.
Thank you. May it please the court, counsel, parties. I just want to touch on some of the statement of facts and the statement of the case, because I think there were some omissions and really misstatements. First of all, right off the bat, my client did not testify that neither did I receive notice of the hearing. that's not in the transcript, she never said that. The parties had 6 children, raised primarily by my client. She was a stay-at-home mom for a period of time, she worked part-time. The most she earned while the parties were living together was about $30,000. The parties have been separated since about 2015. However, they had also been separated from 2010 to 2013. So at the time of the final hearing, they had been separated for 5 of the 7 prior years. It was at that time that my client had only earned up to about $30,000 while the parties were living together. It was after their separation that she obtained her RN degree and got her first job making $60,000. Mr. McWilliams acknowledged during the 6 years preceding 2017, he earned between $40,000 and $70,000. So clearly his income was much higher over the course of their marriage than was my client. And she was a homemaker and she raised the children. He had all of the ailments that he now claims prevented him from being able to understand the separation agreement or receive notices. He had all the same ailments when he was earning $70,000 a year. The fact of the matter is he was an independent contractor. He sold office furniture. He could control how much he made or how much he didn't make. Those were all, if counsel had ordered the transcript of the final divorce proceeding, he would have found out, 1, there was a corroborating witness, and there was testimony presented by my client on these issues. He did not call any witnesses to testify that his physical and mental conditions prevented him from receiving mail, reading and understanding pleadings, affidavits, orders, and notices sent to him, or reading and then voluntarily entering a separation agreement. He testified that he was not coerced into into signing the separation agreement. That is on transcript page 62. He provided no evidence of a continued lack of service of documents by wife's counsel. The evidence only showed of the continued failure of Mr. Williams to acknowledge that pleadings, affidavits, orders, and notices were sent to him and that he received them. With respect to the statement of the case, motion to accelerate final hearing. Sent to Mr. McWilliams at 196 Alta Drive, Monroe Falls, which is the address that my client listed on the case designation form and which was the address that the certified mail went to that he signed for, so apparently that was the correct address. And it was also sent to him by email. There's
Did the
no
court
record.
have record of his email?
I'm sorry.
Did the court have record of his email?
I don't think the court had record of the email. I had the email, and I sent it to them by email. Order for uncontested divorce hearing. Sent to Terry McWilliams, Walter McWilliams, pro se, and me.
Is that the order
That's the
for the
order.
August?
That's the,
hearing?
that's the order for the December 12th, 2017 at 2:00 p.m. order that he claims he never received. Mutual restraining order. Of course, I don't have that the court, the clerk's office actually sent it, but it is their practice, and I think we presume regularity with the clerk's office, sent to him. If defendant does not file an answer, the case will be heard as an uncontested divorce final hearing at 2:00 p.m. on December 12th, 2017.
Don't we look to what's actually evidenced on the clerk's docket?
I'm sorry, Your Honor.
Don't we look to what's actually evidenced on the clerk's docket?
Right, and this is on the clerk's docket. These are all on the clerk's docket.
Can I jump to that November is the 11th, November 8th pretrial? There doesn't seem to be any dispute that he contacted you about.
He admits he contacted me in the transcript.
Okay.
I don't know if you need me to reference
No,
the
not
page
at
of
all,
the
no.
transcript.
So
He
that's,
did.
that's not an
Left
issue.
a message, called him back, told me he had gotten out of the hospital actually 5 days before that, couldn't make the pretrial. It's not uncommon to file motions joint motions. It wasn't really a joint motion for a continuance, but I was trying to help him out.
So was the date of the pretrial that it was supposed to have taken place November the 8th?
Right,
Was November the 8th the day the separation agreement was signed?
yes.
Do you see where at the very least there's some sense of distastefulness about that happening?
No, I'm not sure, Mr. McWilliams had a separation agreement for probably over a year before he came in to sign it. I don't think there was distastefulness in it. If all the facts were before the court, some of them are not in
Well,
that.
and I guess that's what I'm getting to. There's
Right.
things you're saying, you understand we are limited to what's in the appellate record. So-
Right. I'm not sure what you find distasteful, Your Honor, that he signed the separation agreement.
Well, I know that the separation agreement, because I read it, there's actually a portion of it that says, hey, I understand, I can take this to my to a
Right.
lawyer, you
Right.
have a lawyer, and I understand that you don't represent me, and I get that was clearly laid out. I guess the timing of it, just saying, do you understand that could be perceived to maybe be distasteful? I can't come to court because I just got out of the hospital, but I'm going to come here and sign this. Do you understand that someone could make of it what Mr. Fox is now making of it?
You could, if you weren't there. He was fine. We had another witness in the room to make
Okay.
sure that he understood everything.
Okay.
He seemed perfectly competent. In fact, he seemed perfectly competent throughout the entire proceeding. He acted like he knew what was going on.
I'm only here to pose a question.
Yeah. No, I'm just saying, there didn't seem to be, I would never have anyone sign anything that seemed where they seemed incompetent, where they seemed that they were unable to understand. And the fact that he had had the separation agreement for so long, I mean, he rejected it, which means I'm assuming he had, previously he had rejected it. I'm assuming that he had read it.
Is there anything that you would know of in the record that we'd have that would indicate that he had had it for a while and didn't just get it
I don't
that
think
day?
so. Which is interesting. You bring up an interesting point because of the way the hearing was handled. My client had witnesses. In fact, I was there to testify as a witness on her case. I think what the judge did was dismiss under 41B2. And in my brief, I talk about that standard of review because under 41B2, unlike 50A4, the judge is allowed to judge the credibility of the witnesses. And, we talked about where he said that I had not called him about the continuance of the pretrial. He wrote it in his affidavit. I think he even wrote it in his brief before this court. But you look in the transcript and he says something totally different. And, based on that, I think the judge could have questioned why he says he received the complaint for divorce. He didn't receive any of the financial affidavits, although the clerk's office says they sent it all together. He doesn't receive anything in the interim. He doesn't receive anything from me. And in fact, I think that counsel said that there was, a conspiracy to keep him from receiving any notices. He denies receiving anything else until he says he receives the decree of divorce. Now, how is that possible?
Well, counsel, in the decision and order, the court doesn't make a determination whether or not he received anything. It says in paragraph 6, although husband testified he was not aware the matter had been scheduled for final hearing, I'm assuming we're talking about the December hearing, he is charged with the responsibility to stay informed of the status of these proceedings. It doesn't say to me the court finds him uncredible in his testimony that he did not receive it. It just says to me, hey, he knew the proceedings were going on, he's charged with the knowledge whether he had it or not.
Well, where I got that about that he didn't really believe him is that the court said,
Well, the court,
yeah, the court said that clear from Mr. McWilliams' testimony that he simply had a change of heart, that he was aware of the proceedings, that he had been aware of the information.
Right, and I understand that, and I'm just trying to direct it to what the court found as respect to what's relevant in the legal argument about, the court charged him with knowledge of that December hearing because it said, if I'm reading the decision in order correctly, he should have known. Not because he received service or because he's not claiming he didn't receive service.
I don't know what the judge means that he was aware of the proceedings.
No, he didn't say he was aware, he says he should be, she has the responsibility to be aware.
No, I thought he said on transcript 83 to 84, it is clear from Mr. McWilliams' testimony that he simply had a change of heart, that he was aware of the proceedings, that he had been aware of the information.
But that's pretty general, right? In other words, he's aware there's a divorce action going on, clearly. I'm not trying to make this determinative of the outcome, I'm just trying to focus the argument on, the court found that he's charged with the responsibility to stay informed, which would have included the December hearing. And the question is, the legal question is that error or not error? Because the argument is that he didn't receive it, and the court erred in not granting his motion to vacate. Is it error for the court to say he's charged with the responsibility, so whether he received it or not?
Not according to the Ohio Supreme Court. In Ohio Valley Radiology Association, Inc., the court said there's no Ohio statute or rule which specifically requires the court to give notice of the setting down of the date for trial. Ohio courts have traditionally held that while some form of notice of a trial is required to satisfy due process, an entry of the date of the trial on the court's docket constitutes reasonable constructive notice of that fact. And then I cite other cases that say the same thing. One case from Franklin County says he has a duty to check on the proceedings of the court to assure that he will be at the hearings or trial. So you just can't simply state, sit back, know things are going on.
Well, the entry on the court's docket, though, was from March of the following year. Was it March?
No, it was,
And then it was accelerated to December of.
the notice was November 27th. It was filed November 27th, 2017, and it claims it was sent to Terry McWilliams, Walter McWilliams, and me, stating that an uncontested divorce hearing before Judge Don Quinn will occur on December 12th, 2017.
What was prior to that? What did the judge originally set before he was asked to accelerate it?
I think it was in March of 2018. That's a notice he says he received. He receives all the notices that are good for him, but he never receives anything that would hold him accountable. I think that is a factor the judge could have taken into consideration. Otherwise, I mean, this is going to open up the doors to anybody saying, oh, I didn't get the notice, and I could have done better at trial than by my agreement. But I mean, I was surprised to see that there was constructive notice. It makes you know you've got to check the docket frequently because, I mean, I think the case law is clear. I did point out the one decision by this court, Ammer versus Werner, 2012 case, but in that case it was set down as a pretrial on the docket, and then they had a trial instead, which I think distinguishes it from this case. We think he had appropriate notice. He knew what was going on. He just had buyer's regret. So we asked the court to affirm. Thank you.
Thank you. Well, I can say for the first time in my career of appearing before any court of appeals, and there's been several, I've never had more of an urge to object than today. I can only say because of my limited time, I would ask this court to pay careful attention to the transcript, which I know you will, and the briefs, and the exhibits. Had counsel actually looked at her own client's exhibit about the text, she would have found that her own exhibit said she didn't get notice of the December 12th, 2017 hearing. This was after my client called her saying, hey, what's with this decree of divorce? I didn't get notice of the final hearing. So that's in the exhibit. Everything else that was discussed in probably the first half of Appleby's argument isn't in the record. It just isn't there. The idea that he picks and chooses what he gets was explained by him at the hearing, because some of the things were given to him by his wife. He didn't get the original documents. The court will note there was a waiver of service. Why was that? Because she gave it to him and made sure he got to the initial uncontested hearing in August of 2017. It was then that he was personally notified. They told them of the November 8th hearing date. We know what happened here. We know by the language of the judgment entry decree of divorce that there was no intent that he would be at that final hearing. There is no signature line for him. He has no lawyer.
I know you have a very limited time, but I indicated to counsel for the appellee that whether he received something or didn't receive something is not something that was determinative on the outcome based on what's in the entry. Do you disagree with that?
That what he did or did not receive was not determinative of the outcome?
In the
I
court's
believe that's what the court said. I think that's kind of what the flavor is. Basically what the court said was, hey, he was wheeled in, he signed this thing, and we're going to hold him to it. Even though he didn't show up at the final hearing to say whether or not he thought it was fair and equitable. I mean, that is a process we do in every case. Dissolutions. The dissolution statute says we're going to file a dissolution. The paperwork's going to say fair and equitable. You get 30 days as a cooling off period before we set the final hearing. And by the way, if you show up at the final hearing, even though you've already signed those agreements, and you say you don't believe it's fair and equitable, it's thrown out. It's thrown out. That's the statute. Why would we treat this any differently? I'm out of time. Thank you, Ern. Thank you for your time.
Thank you both for your arguments.
Thank you, Your
Court will
Honor.
take the matter under advisement and issue a decision in due course. Clerk of courts will send each of you a copy of the decision on the date it's released. You could also view the Supreme Court of Ohio's website, which also posts this court's decisions.